Hello everyone, welcome to our presentation. We're doing this presentation on behalf of Quinnipiac University. The authors of this presentation are Michelle Antonucci, Jackendria Holden, Julia Marone, Paul Moore, and Alyssa Sagnario. Our professor is Miss Angela Matti. Our presentation topic: an integrated analysis of discrimination against lesbian, gay, bisexual, or transgender LGBT employees in the workforce. The purpose. Our objective is to provide an integrated analysis and examination on how existing federal, state, and local employment laws apply to employees who identify as lesbian, gay, bisexual, or transgender. The agenda. In current issues and statistics, there's a need for change. History of LGBT discrimination in the workforce is why there's a change needed. We're going to take an examination and analysis of current laws, and we're going to look at LGBT case analysis and outcomes. Discrimination can be in the form of denying employment or firing an employee because of his or her race, color, religion, nationality, age, sex, gender, or disability. Our project specifically covers transgender status and sexual orientation discrimination against LGBT employees. Sex discrimination involves treating someone, an applicant or employee, unfavorably because of that person's sex. Examples of sex discrimination include not hiring an applicant because of his or her gender identity or sexual orientation, firing an employee because of his or her decision to undergo gender transition, failing to promote an employee because of sexual orientation and/or gender identity. Discrimination is a nationwide problem that impacts all employees regardless of race, religion, national origin, and sex. Organizations spend countless amounts of time and money on resolving discrimination issues, as acts of discrimination have and will always have a negative impact on organizational morale, culture, employee engagement, long-term growth, and profitability. Issues: discrimination of lesbian, gay, bisexual, or transgender employees. Laws are outdated and inadequate. Has a negative impact for employees and employer. Costly for employers. Decreases employee engagement and motivation. People who identify as LGBT face discrimination at an alarming rate in the workforce, with few and consistent laws to protect them. A study conducted by the Williams Institute on Sexual Orientation Law and Public Policy finds that 15 to 43% of LGBT workers have experienced some form of discrimination on the job. 8 to 17% of LGBT workers report being passed over for a job or even fired because of the sexual orientation or gender identity. 7 to 41% of gay or transgender workers were verbally or physically abused or had their workplace vandalized. 12 to 30% of straight coworkers have actually witnessed discrimination based on sexual orientation and/or sexual identity. 47% of workers have experienced an adverse job outcome because they are transgender. This includes 44% who were passed over for a job, 23% who were denied promotion, 26% who were fired because they were transgender. Furthermore, LGBT persons suffer from socioeconomic disparity due to the direct causes of workplace discrimination. LGBT discrimination generates job instability and high turnover rates, which results in greater unemployment and poverty rates. This statistic is especially true for older LGBT persons, as they experience the highest poverty rates than any other group. Transgender individuals are twice as likely to be unemployed and are 4 times as likely to live in poverty. LGBT individuals make up a large portion of the American workforce, yet on a daily basis lack full protection under the law. The LGBT civil rights movement is not a relatively new concept, but it has gained more attention in recent years. Beginning in the early 1950s, well into the 1970s, discrimination based on sexual orientation has been common in the workplace. In 1950, Senator Joseph McCarthy set off a lavender scare. He believed that the U.S. State Department and other government agencies had been infiltrated by communist agents. But few Americans know that McCarthy also charged that the government had been infiltrated by homosexuals and that they posed a threat equally as grave to national security. This fear that gay men and lesbians could be blackmailed into revealing state secrets resulted in a systematic campaign to identify and remove all government employees suspected of homosexuality. In 1953, the pressure to strengthen national security procedures became codified when newly elected President Eisenhower signed Executive Order 10450, which expanded Truman's loyalty program to include issues of character and suitability. For the first time, sexual perversion was included in the list of behaviors that would exclude one from holding a job with the federal government or receiving a security clearance from a federal contractor. Agencies set up new policies and procedures for detecting and removing men and women suspected of being gay, lesbian, or bisexual. Applicants were personally interviewed to look for subtle signs of homosexuality, such as gender nonconformity, invoking the notion of guilt by association. Investigators checked whether an employee's friends or roommates were gay. Some were placed under surveillance to determine whether they frequented gay bars or associated with known homosexuals. Local police agencies were encouraged to clamp down on local gay meeting places and then share their arrest records. Investigators vigorously interrogated civil servants about their private sex lives and offered a lie detector test as one of the only means of establishing their innocence. Between 1947 and 1961, more than 5,000 Americans lost their jobs or resigned under pressure they faced based on their sexual orientation. One of the first gay employees to fight his termination was Dr. Frank Quinnipiac, a World War II veteran who worked as an astronomer for the Army Map Service. In 1953, President Eisenhower had signed Executive Order 10450, banning gays and lesbians from serving as federal employees. In 1957, Dr. Quinnipiac was fired for being gay. In 1961, he filed the first gay rights appeal to the U.S. Supreme Court. He argued that anti-gay discrimination was no less illegal and no less odious than discrimination based upon religious or racial grounds. This was not an issue of morality or national security, he argued, but of human rights. Quinnipiac testified before Congress, led pickets in front of the White House, and helped other federal workers who were terminated because of sexual orientation fight their dismissals in court. Quinnipiac also led the movement against the American Psychiatric Association (APA) for its classification of homosexuality as a mental illness. Though by 1969 several U.S. federal courts had ruled in their favor, labeling workplace discrimination policies against LGBT persons an unconstitutional infringement on American freedoms. In 1975, the U.S. Civil Service Commission lifted its ban on gay employees, a victory Quinnipiac pursued relentlessly for nearly 2 decades. In highly sensitive agencies such as the Federal Bureau of Investigations and the National Security Agency, the ban on gay and lesbian employees would linger into the 1990s, when President Clinton finally signed executive orders banning discrimination on the basis of sexual orientation in federal hiring practices and in the granting of security clearances. In the United States, discrimination is illegal. The most familiar anti-discrimination laws are Title VII of the Civil Rights Act of 1964 and the Equal Pay Act of 1963. Title VII of the Civil Rights Act of 1964 does not explicitly include sexual orientation or gender identity in its list of protected bases, but the Equal Employment Opportunity Commission, EEOC, enforces Title VII to include gender identity or sexual orientation regardless of contrary state or local laws. The Equal Pay Act was enacted in 1963 to close the wage gap between men and women. The EPA makes it illegal to pay one member of a sex more money for the same or similar work with no justification other than based on sex. Recent research has shown LGBT employees, especially homosexual men, are likely to make less than their heterosexual counterparts. The EEOC has chosen to try cases where wage discrimination is based on sexual orientation or gender identity under the EPA and Title VII since it involves sex discrimination. Executive Order 13672 is a federal statute that bars federal contractors from discriminating against employees based on sexual orientation or gender identity. President Obama signed Executive Order 13672 as an amendment to Executive Order 11246, which only covered discrimination based on sex. The military has experienced more controversy on the treatment of gays and lesbians than any other government institution. Don't ask, don't tell was a policy implemented in 1993 that called for homosexual service members to be discreet about their sexual orientation. In return, the military would not fish out homosexual service members. However, thousands of service members were discharged while this policy was in effect. President Barack Obama repealed the policy in December 2010. Although Don't Ask, Don't Tell was repealed, there was no reparations made to service members who were affected by it. State laws and LGBT discrimination in the workforce. The 14th Amendment of the U.S. Constitution Equal Protection Clause prohibits states from denying equal protection under the law within its territory. Senate Bill 703 in California prohibits companies who have contracts with the state of California from discriminating against employees based on gender to include gender identity. However, fewer than a third of all U.S. states have laws protecting from discrimination based on sexual orientation, and only a handful prohibit discrimination based on a person's gender identity or expression. Senate Bill 703 in California is an example of state laws that bar discrimination against LGBT employees. This law covers both sexual orientation and gender identity. Senate Bill 703 prohibits companies who have contracts with the state of California from discriminating against employees based on gender to include gender identity. This map is current as of January 26, 2016, to reflect states that have laws in place against discrimination based on sexual orientation, gender identity, or both. In gray, you will find states that have absolutely no laws in place, while only 2 states, Wisconsin and New Hampshire, are the only states in the nation that have laws that prohibit discrimination for only sexual orientation. The states in blue have laws that prohibit discrimination for both sexual orientation and gender identity. As you can see, a large number of states have no laws in place against the LGBT community from discrimination, and states with no protection for LGBT employees, federal law, Title VII, is usually enforced based on the case. Pending laws that protect LGBT employees. Employment Non-Discrimination Act, ENDA, is legislation proposed in the United States Congress that would prohibit discrimination in hiring and employment on the basis of sexual orientation or gender identity. Broad exemptions for religious organizations. ENDA makes very broad exceptions for religious organizations. The exemption consists of 3 parts: a complete exemption for houses of worship, parochial, and similar religious schools and missions; a codification of the so-called ministerial exemption, recognized by many federal courts, exempting positions at religious organizations that involve the teaching or spreading religion, religious governance, or the supervision of individuals engaged in these activities; a provision allowing religious organizations for classes of jobs to require employees and applicants to conform to a declared set of significant religious tenets, including ones which would bar LGBT people from holding the position. These exemptions make it possible for LGBT employees who are employed by religious organizations to lose their jobs and/or be passed over for jobs in the church. For example, a religiously affiliated hospital could require all nurses to avoid engaging in same-sex activity. If the nurses violated this policy, they could be terminated. If ENDA was enacted into law, this would not be illegal because of the 3rd exemption. ENDA has lost support from some gay right groups because of its broad exemptions for religious organizations. Many will agree that there is room for improvement to ENDA's exemption policies that will balance out the protection of religious freedom while ensuring the rights of LGBT employees are not violated. Overall, the passage of this act would be beneficial to ensuring that LGBT employees are protected from discrimination nationwide to include state and local levels. In June 2011, a transgender male to female, Mia Macy, filed a formal complaint against the Bureau of Alcohol, Tobacco, Firearms, and Explosives. December 2010, she had a phone interview with Walnut Creek Crime Laboratory. They advised her that she will be given the position if her background check clears. Macy was in the process of a background check for a new position at the Walnut Creek Crime Laboratory in San Francisco. Macy at the time was still identifying as male. She advised the agency that she will be transitioning from male to female. Suddenly, the Alcohol, Tobacco, Firearms, and Explosives Agency informed Macy that the position will no longer be available due to budget constraints. When Macy contacted EEOC, they informed her that the position was not cut, but had been filled by another candidate. The EEOC concluded that transgender discrimination is sex discrimination and determined that Macy's claim was legitimate under Title VII. Lila Jamison filed a claim against the United States Postal Service in November 2012. Jamison, a transgender woman, filed 4 claims with the EEOC on the subject of harassment based on sex. The 4 claims included that her work was tracked and signed off on, her locker was broken into, and property was stolen. Her supervisor refers to her as he, and she was scheduled for an investigation interview in October 2012. The EEOC dismissed these claims because 2 of them were subject of a complaint already pending, and the last 2 was failure to state a claim. Jamison appealed the dismissal of the claims and filed the complaint of her addressing her as him and the investigative interview as one claim, as stated in the article on transgender rights in the workplace by Eve Massenter, Rachel Junofrio, and Rachel Coe from the Brazil, Sash, and Wilson Attorneys at Law. The Commission explained that supervisors and coworkers should use the name and pronoun of the gender that the employee identifies with in employee records and in communications with and about the employee. Intentional misuse of employee's new name and pronoun may cause harm to the employee and may constitute sex-based discrimination and/or harassment. In 2010, a transgender discussed her transition with her supervisors at the U.S. Army Aviation and Missile Research Development and Engineering Center. Tamara Lusardi, a disabled veteran, worked as a software quality assurance specialist in Alabama and was undergoing a transition from male to female. During this conversation with her supervisors, they all agreed that Lusardi would use the executive restroom, and when her transition was completed, she will then use the common women's restroom. The deputy program manager had to approve these plans, and he did. Lusardi emailed the staff regarding her situation in case there were any questions. After Thanksgiving 2010, she started to present herself as a woman. A few instances, the executive restroom was out of order or being cleaned. Lusardi used the bathroom she identified with, the women's restroom. Her team leader addressed her regarding the restrooms, and she notified him that the executive room was out of order. Her team leader also used the wrong pronouns when addressing her. In September 2011, Lusardi notified an EEOC counselor, and in March 2012, the formal complaint was made. The Army dismissed these complaints because she agreed to use an executive bathroom and the addressing of the wrong pronouns was an accident by the team leader. In September 2013, Lusardi appealed the results with the EEOC. The EEOC found the Army's decision to dismiss the complaints by Lusardi a violation of Title VII. In May 2013, a formal complaint was filed for the discrimination of sex from Cyrus Ethan Drew. Drew filed 2 complaints against the Department of Veterans Affairs, which was provided in the case complainant v. Eric K. Shinseki, Secretary, Department of Veterans Affairs, on April 4, 2012. Complainant requested that the Shreveport Information Security Officer change his name in the facility's Vista computer system, and it took over a year to make the correction. And on April 19, 2013, he was threatened and his privacy violated when the Information Security Officer accessed his background information. The Department of Veterans Affairs felt that Drew was not affected by the inconvenience of the name change. They also dismissed the second claim because Drew did not notify the EEOC. Reported in the case complainant v. Eric K. Shinseki, Secretary, Department of Veterans Affairs, the EEOC found the Department of Veterans Affairs to be improperly defined the complaint as consisting of 2 separate claims rather than claim of ongoing harassment. In doing so, the agency dismissed each claim for separate reasons. When properly viewed as a claim of sex-based harassment, we find complainant has stated a claim of a violation of Title VII. A gay male, David Baldwin, contacted the EEOC in August 2012 to discuss a complaint that he did not receive a permanent position due to his sexual orientation. Baldwin was working as a temporary supervisor at the Federal Aviation Administration, FAA, in Miami, Florida. When he learned about the vacant permanent position in June 2012, he contacted his supervisor to request to be considered. Baldwin did not have to apply for the vacant position because all temporary positions were automatically considered for any vacant permanent position. Baldwin also discussed that his supervisor made several negative comments about his sexual orientation. In October 2010, Baldwin was notified that his temporary position was ending and he would have to return to his previous position. In December 2012, a formal complaint was filed stating discrimination for sexual orientation. In the case Baldwin v. Fox, it stated the conclusion of the case as the Commission explained that although sexual orientation is not explicitly listed in Title VII as a prohibited category on which to base employment decisions, the question of whether Title VII covered this discrimination is the same as in any other Title VII case involving allegations of sex discrimination. As cited this presentation, various rulings by Federal Equal Opportunity Commission, EEOC, extends Title VII's prohibition on sex discrimination to prohibit discrimination on the basis of sexual orientation and gender identity. However, EEOC rulings are not binding on private employers, and federal courts may rule differently. The federal government must take appropriate steps to ensure the LGBT citizens are treated as fairly as any other American citizen and/or protected class. The EEOC's decision to try discrimination cases based on sexual orientation and/or gender identity as sex discrimination under Title VII shows that progress is being made to ensure some protection for LGBT employees. Although this is a step towards progress, more must be done to ensure equality in the workforce for all LGBT employees.